Good morning and welcome to this webinar from 13 Essex Chambers. My name is Richard Harwood. We're going to talk about the decision of the Supreme Court in Dill and Secretary of State on listed buildings, urns and the art market. I was leading counsel for Marcus Dill through the whole of the proceedings, and just like to introduce the rest of the panel. Who wants to go first?
Apologies, my name is Rebecca Reynolds and I'm a member of the Institute of Art and Law and an assistant researcher, as well as a heritage consultant.
I'm Nigel Hewitson. I'm a former legal director at English Heritage and co-author of the book Listed Buildings and Other Heritage Assets.
And I'm Catherine Dobson, a barrister at 13 Essex Chambers, and I was junior counsel in the Supreme Court in the Dill appeal.
Okay. Well, we're going to talk about the case, what the facts were, what the decision was, and look at some of the implications of that. You'll find at the bottom of the screen a Q&A. So if you have any questions you want us to consider, do sort of put those in and we'll pick those up as we go through the discussion. The whole thing will be about 3/4 of an hour or so. So if I can start by taking us through as to what we're dealing with. Nice thing about art cases is that, they're decorative, they're dramatic, and they usually have quite a lot of history to them. The Dill case concerns a pair of 18th century lead urns, which are attributed to John Van Nost about 1700 when they were made. And they were originally made for Rest Park, which was the home of, at the time, the Earl of Kent and subsequently the Duke of Kent. So when we think that they were finials, so originally designed to go on a building. But by the late 1720s, they had been placed on limestone piers at Rest Park, and they remained there for 2 centuries. There's some quite nice pictures showing where they were. 1939, Rest Park was sold by its then owners, and the family took the urns and a variety of other items, including a statue of Diana and a Thomas Tompion sundial, with them. And the family moved around over the years, moved 4 times, and kept taking the items with them, putting them in the gardens where they were. 1973, these items end up at Illicott House, which was already listed as a Grade 2 building. It's then listed, specifically listing the 2 items, each pair of urns and piers, in 1986. Now, a bit odd as to what happened there. There's no evidence of consultation. Certainly the details went on the land register, local land charges, quite late. And it's a very spare register entry. It describes them as 18th century urns. So the history isn't picked up. So there's no evidence that the family were consulted, and certainly the family's recollection, the estate records, have no mention of the listing. So by the time we get to 2009, Marcus Dill, who's inherited it through the family, had the items sold at auction. Neither he nor the auctioneers nor the purchaser were aware of the listing. Subsequently, about 6 years later, the local authority gets told by somebody that there are listed items which no longer seem to be there. And there's then matters raised by the local authority with Marcus Dill. They make the point that Historic England's policy is not to consider delisting whilst there's the prospect of enforcement action, and ask Mr. Dill to apply for a listed building consent. That's applied for, it's refused. The authority issue a listed building enforcement notice requiring the items to be brought back. Mr. Dill appeals. I involved Mr. Dill at that stage, and amongst the arguments which was being made in the planning appeal was that these items were not in fact buildings. Therefore, even though they're on the list of building consent wasn't required. The inspector decided that because they were on the list, he couldn't look at whether or not they were buildings. That was a point which the inspector had raised. The local authority hadn't raised that, and dismissed the various other grounds of appeal. Mr. Dill challenged those decisions in the High Court. We found in favour of the inspector's decision, as did the Court of Appeal. Permission to appeal was then granted by the Supreme Court, and at that stage, our legal team was augmented by Catherine Dobson coming in as junior, at which point, it's fair to say, things started looking up. So I'll ask Catherine to explain how the Supreme Court dealt with the first issue.
So the first issue in the appeal, and until the case reached the Supreme Court, the decisive issue was whether Mr. Dill could challenge the listed building enforcement notice and a refusal of listed building consent on the basis that the items were not buildings. The inspector proceeded on the basis that he could not go behind the listing and so could not consider whether something on the list is a building. And the High Court and the Court of Appeal agreed with that. Mr. Justice Singh, as he then was in the High Court, and Lord Justice Hickenbottom in the Court of Appeal found that it was clear from the statutory scheme that Parliament did not intend an individual to be able to challenge whether something was a building in a listed building enforcement notice appeal. And there were two principal parts of their reasoning that led to that conclusion. First, they said this followed clearly from the construction of section 1.5, which defines a listed building as a building which is for the time being included in the list. And they, the High Court and the Court of Appeal, placed emphasis on the words for the time being as supporting the construction that the list is determinative or conclusive of the status of the subject matter as a listed building. And the second part of their reasoning was they said that Parliament's intention was revealed by the fact that the grounds for a Section 39 appeal expressly enabled an appellant to raise issues concerning the merits of the listing, but do not expressly refer to a challenge to the validity of the listing on the basis that the items are not a building. And they said that if Parliament had intended an appellant to be able to challenge the listing on that basis, it would have and could have made that clear. So if we go to the next slide, the Supreme Court, by contrast, did not hesitate in concluding that Mr. Dill was entitled to challenge the designation of the items as buildings in the enforcement notice appeal, which begs the question, why the difference? The case really turned on a question of statutory construction rather than matters of policy. So it is surprising to see the higher courts reaching such opposite conclusions to a strong Court of Appeal and High Court. And the difference does raise, does turn on a different approach to the questions of statutory construction at issue in the appeal. The Supreme Court disagreed with the interpretation of section 1.5. It noted that there are two elements to the definition of a listed building. A listed building must both be a building and it must be included in the list. And from this straightforward construction, they came to the point that if what is on the list is not a building at all, there's nothing in the Act to provide that mere inclusion on the list will make it so. So that was the first point of difference. It also disagreed with the suggestion that because the Act does not include a specific ground of appeal to challenge whether something is a building, Parliament had made clear its intention that an enforcement notice should not be amenable to challenge on that basis. The court said that as a matter of construction, such a challenge would fall within the scope of section 39(1)(c), which is a challenge on the basis that the matters alleged to constitute a contravention of section 9 do not constitute such a contravention. The point being that there be no contravention of section 9 if the relevant item was not a building. But they also made a broader point that fairness requires that an individual who's subjected to an enforcement action should be able to challenge every aspect of the merits of the decision to serve an enforcement notice. So the difference is explained by a difference in approach to construction of these statutory provisions. But I think the fundamental difference in the Supreme Court was the starting point that the justices adopted. They started from the position that the case raised a principle of fundamental constitutional importance, that individuals affected by coercive administrative measures should have a fair opportunity to challenge these measures in court proceedings. And this was clear from the attitude of the justices at the hearing in the Supreme Court, and it's also clear from the judgment. It's the first point that the Supreme Court makes in the section of the judgment addressing the first issue. And this is important because when you take as your starting point in an exercise of statutory interpretation that this presumption is in play, then you start from a presumption that Parliament will not legislate to prevent individuals challenging administrative measures. And by contrast, the lower courts, it seems, approach the issue from a different starting point. Their principal concern seems to have been the integrity of the list and the importance of certainty and finality. And you can see why this would lead to a different interpretation of section 1.5. If you take this as your starting point, then it makes more sense to construe that provision on the basis that being on the list is conclusive. So the Supreme Court and the took a fundamentally different starting point from the lower courts and rejected the argument that certainty should trump principles of fairness. And for my part, I think it's an important reminder that considerations of certainty and finality in administrative decision making do not ordinarily trump this fundamental principle of the rule of law. Richard, I think you're still on mute.
It struck me from the way in which the Supreme Court was constructing the judgment that they were sort of looking at it from quite a broad sense. We had a lot of argument from all the parties about the listing process, whether the absence of a duty to consult in advance, the informal nature of the review process, lack of a statutory review mechanism, and those issues about whether that process worked and whether it might, as I made in submissions, might lead to an unfair and ill-informed judgment in some cases. But none of that makes its way into the judgment, because it seems to me that the Supreme Court are stating the basic principle that you have a right to challenge unless the statute says you don't. And there's no express ouster. And Lord Carnwath doesn't then find a great deal of difficulty in saying, well, the planning process through an appeal to an inspector is a very sensible mechanism for resolving these issues, rather than saying, oh, well, it's judicial review or nothing on that. So it seems to me they've taken it quite broadly. What do you think, Catherine? So, Catherine, you're muted.
Yes, I agree with that. Their starting point is from first principles. You approach this exercise of statutory construction from the perspective that individuals should have the ability to challenge administrative decision making in full. And then there's a question about where it's convenient to do it, and in this particular context, it makes perfect sense for that to be dealt with within the existing appeal structure under the Listed Buildings Act.
Okay, I'll move on now to look at the second issue, which was the question of whether or not what we were dealing with was a building. And that was sort of put in the context of being really firstly a decision which would, best of the court decision, would be sending it back to the inspector, but also debate about to what extent it's an evaluative question. It goes to some of the issues as to why the court thought it was suitable for an appeal in front of an inspector to deal with those. So the court was looking at the legal principles to be applied, and there's a bit of debate as to how far it could then go into expressing a conclusion on the urn. But as we'll see, it goes sort of some way. The critical part of the definition, as maybe as we'll know, in section 1, subsection 5 of the List of Buildings Act is that a list of building means a building which is for the time being included in the list. And then for the purposes of this act, any object or structure fixed to the building, or any object or structure within the curtilage of the building, which are not fixed, the building forms part of the land and has done so since before 1st of July 1948. 1st of July 1948 being sort of year zero for the modern planning system. Now, that comes into sort of two elements here. The first part, building for the time being included in the list, is critical when you're considering something which the list has identified as a listed building. And then the remainder, what Lord Carnwath refers to as the extended definition, are objects or structures which, whilst they're not specifically listed, become part of the listed building, either by fixing or by being curtilage structures. And the judgment, first of all, looks at that extended definition and applies what's fairly well established, although actually only in a relatively limited number of cases, which is looking at concepts of a real property law. It's only applied in a limited number of cases. There's a decision of the High Court called Cawthorne, which the Dill judgment goes into in quite a bit of detail, which concerned position before the extended definition as to whether items which had been added, which were sort of in a list in the building preservation order, items within a building, various panels and wooden equestrian statues and the like, whether they were part of the building in that sense. And that looked at the property approach. The House of Lords in Debenhams, useful speech by Lord Mackay, but purely obiter, saying the property law approach applies to whether something is fixed, and is also accepted by the High Court in a case called Kennedy. But this is ultimately the first ruling at a level above the High Court that applies. And so if you're looking at whether something is part of the land or whether it's fixed, you apply two concepts which are well known in property law. Look at the method and degree of annexation and the object and purpose of annexation. And the classic case, the one that sort of kicks off land law lectures, certainly used to do in my day, decision of the Court of Appeal in Berkeley and Poulet, which concerned various paintings within a house and a statue and a sundial outside the house. And in that situation, the Court of Appeal, by 2-1 majority, considered that those items, even the heavy ones, like very heavy statue, wasn't part of the land because it wasn't part of the design. The plinth statue was part of the land. The statue wasn't for property purposes. And that's been followed recently in a case involving Tower Hamlets and a Henry Moore called Old Flow, which had been sort of moved around. One of the issues in the case is whether that was ever actually part of the land where it was placed in East London GLC council housing estate. So the court confirms the property law approach to the extended definition, but then drew a distinction between what is a building specifically listed and the extended definition. Interesting how it went in the court and in the proceedings as a whole. In the case from the start, we had argued from the appeal to the inspector onwards that there were these two potential approaches, property law and what we referred to as the Skerritt's approach in planning law to what is a building. So it always argued on those two bases, but inclined towards property law as perhaps being the right one. In the Supreme Court, Lord Carnwath's comments in the course of argument were effectively well treated all the same approach. Lord Sales was far more sceptical about whether the property law approach was the right one for whether something was a building. And ultimately, the view which Lord Carnwath took in his judgment reflected rather more the comments of Lord Sales in the hearing, that whether something is a building is not to be judged by the property law tests, but by an approach that's come together through the planning process and some earlier rating decisions. Skerritt's was a case about the Grimsdyke Hotel in North London, which was a Richard Norman Shaw rather grand Victorian Gothic design, and prompted a number of cases, one of which concerned whether or not the marquee which had been erected in the grounds, a very large marquee, was a building or not. It was building operations which required planning permission. And the court said there were three factors to look at: size, permanence, and degree of physical attachment. And Lord Carnwath took the view that that was the right approach to whether or not something was a building in property, in the listed building sense. And a number of matters had been mentioned as examples, particularly from the Secretary of State, looking at Historic England's guidance. We've got two of them up on screen here. One is some dinosaurs at Crystal Palace, which have been there not quite since the dawn of time, but since the 19th century. Took the view there's no difficulty in saying that those were buildings with wide different structures and erections. And then a listed statue, Noah Henry Moore, a reclining woman at Dartington. And Lord Carnwath said, well, the plinth is pretty solid. If we look at it closely, it's comprised of writing blocks and so on. That would be a building compared to, you can see that perhaps the statue was sufficiently attached to the building, but didn't see too much difficulty there. But what he was far more cautious about were the example, which again comes from the Historic England Garden Selection Guidance, of Rest Park itself, where a whole series of items are mentioned, including urns and vases, as being being listed buildings either in their own right or as being caught by the listing of the rest of the building. And he was very keen to emphasise the need for demolition involved in dismantling. So raise the question we'll come to in a moment as to how wide that all goes and what is or isn't going to be a building. The case has been remitted in terms of the listed building enforcement notice, which was the one that was significant in this case to the Secretary of State, and the court also expressed a view as to whether there's any merits in the proceedings continuing. But I want to bring our sort of panel in and start sort of looking at what the implications of this are for what's listed and for the art world generally. Nigel, do you want to kick off on where you think the judgment takes us?
Yes, I think the first thing to say is that the Dill case it's almost a perfect storm. It's an unusual set of circumstances where Mr. Dill was unaware that the items, to use Lord Carnwath's terminology, had been listed, and was remained unaware until enforcement proceedings were in contemplation, so that it wasn't possible under Historic England's policy to request that the items be taken off the list on the basis that they were not actually buildings. So he was left in a cleft stick. I think it's far more desirable that owners are not put in that position, but hopefully most owners are aware of what items / buildings on their property are listed. But it's, I think going forward, certainly in terms of new listings, I think one of the takeaways for Historic England, and I think there are some representatives of Historic England on this webinar, is that they need to think about revisiting their listing guides to address the issue of whether within the Skerritt's definition things are buildings. There was some kind of implied criticism from Lord Carnwath that the guides talk a lot about architectural and historic interest and say very little about whether things are buildings. In the longer term, I do wonder whether an adoption in England of the provisions that already apply in Wales and Scotland that allow some limited grounds to challenge at the outset a decision to require in Wales Cadw and in Scotland, Historic Environment Scotland, to review their provisional decision to list a building. At the moment, as I understand it, certainly in Wales, the grounds on which you can do that are limited to whether it's of sufficient historic or architectural interest. But it would be, that's by means of regulations, so it would be easy enough to amend the regulations to include whether it's a building or not. And hopefully, as to the future, that will avoid us getting into this situation. I think that's the first takeaway.
Rebecca, what was your sort of reactions to the judgment?
I think while it's provided clarity into what will be classed as a building, I think local authorities need to review what they've got within their sort of sphere of control and review those features and make sure that it is therefore clear for the owners, because of course otherwise we're going to have situations of people finding out what they've got and then questioning it.
I think it's there's a point Nigel makes, that it came about in some very odd circumstances that hopefully, and I think we'll hope that the issue is spotted before something's been moved rather than afterwards, so it doesn't have to be dealt with in an enforcement context, but sometimes it would do. But also there's this question which sort of Nigel raises of the listing process as to how effective that is as an information gathering exercise. One of the very unusual features of this case was that the items had only arrived relatively recently at Idlicott when they were listed, and that point is not remotely picked up in the list description. So do we need a more formalised system in England, as they do in Wales, in the listing process, that you have interim protection whilst there is formal consultation with owners, which would hopefully have picked up a number of the issues which have now become important on Idlicott?
And that would be relatively easy to do, because all that would need to happen would be that sections 2A to D of the List of Building Act would just need to be applied to England as they currently stand. There would need to be slightly different regulations, but it would be fairly simple.
Yeah. So that sort of quirk in the regulations came up in the hearing that I was asked, I think it was by Lord Wilson, whether there was some review mechanism in Wales, which we picked up in the documents, and they say, well, so there is, but the basis on which you can apply for the review is solely on the basis that the items at the building is not of special interest, and which got a sort of not very helpful sort of response to that. And if you are going to use the review process as one of the mechanisms of trying to resolve the question, then obviously needs to be able to ask the question whether or not it's a building. And in that situation, the review decision is one which is not capable of being challenged, so it could be seen as being conclusive. But it brings that forward as, I think, an issue to be addressed. Now, amongst the topics which we've had sort of coming in from the questions, and thank you to everyone who's put those through, is what the implications of Lord Carnwath's judgment are for the smaller items which are being listed. Question draw attention to lampposts, milestones, and other sort of miscellanea there, as to whether or not Lord Carnwath is drawing the boundaries of what should be listed differently to the way in which it's been applied Where do we think we might be on that?
I think the first thing to say is I did a quick search of the online list this morning, just to cover statues and urns, and there are 4,079 list entries that include the word statue, and 8,864 list descriptions that include the word urn. That's not to say they are all statues and urns listed in their own right, but it illustrates that we're not talking about insignificant numbers here. I do think that this will have a limited effect in that it's only going to affect things that don't satisfy all the three tests in Skerritts. That they're not sufficiently large, they're not sufficiently permanent, and a lot of statues, a lot of street furniture, milestones, they are clearly fixed to the ground. They clearly satisfy the degree of permanence, and I think what's at risk is relatively small items that are in one piece and can be brought on site easily without the need for machinery or cranes and all that sort of thing, and are not necessarily fixed very firmly to the ground. So I'm not sure we need to panic that all these lampposts, milestones and so on are suddenly not listed. I think that they probably validly are. I think it's more a question of if people are thinking of removing what they may personally think of as chattels, it would be a good idea to just check, is it listed, and do you want to challenge that listing before you get into the cleft stick of there being enforcement proceedings in train, and Historic England understandably not wanting to interfere with those enforcement proceedings.
I mean, my take on it is that things like signposts and telephone boxes and so on are, firstly, also permanently, they're fixed to the ground, often very, very, very firmly fixed. They are permanent in the sense that they are intended to stay there until something changes, which is not anticipatable as being a change. So they are intended to be permanent. There will possibly in some cases be size issues where you could really say something's a building within a wide building structure or erection sense, but I don't think that's going to be too problematic in terms of those sort of, we might say, those public structures. Where the case is more important, but I think illustrating what I seemed to be roughly the right approach, is on things like garden ornaments, garden statues, the works of art in that sense. What Carl was referring to as urns and vases, some of which are specifically listed. So you look at the building, some of which the debate about is whether or not they are caught by curtilage listing. But all have that sort of issue as to sort of how long they are there, to what extent they're part of the design. And I think those sort of history and design issues, which are relevant to the property test, and always relevant to the property test, are also relevant to the question of permanence when you look in the Skerritts type approach. So something which is quite fun about dealing with these situations is particularly around an existing old house, you are quite often looking at the history of the items, going back into the estate records, getting the art historians in, looking in country life, which is a phenomenally good source, to see what has happened to this statue since the second son of the Earl bought it when he was doing the grand tour in the mid-18th century, and try and take that view. So those are issues which have been alive but haven't really sort of hit into open litigation are current. And I think the Lord Calmouth approach is one that's perhaps more permissive than sometimes the listings have seen. Although my experience has been that actually when these issues do get discussed with Conservation Office and with Historic England, there's normally not that much difficulty in the owners and the public authorities reaching a settled conclusion as to whether or not the items are subject to listing or not. But Rebecca, where does that sort of take us for the art market, do you think?
Well, I think that there's a difference with these situations. They're going to be looked at between these features that are within the public realm, i.e. on the street, and therefore are not in the private hands of an individual. When someone wants to sell or is considering it, obviously now, as opposed to in 2009 when Mr. Dill sold them, you can check if something is listed on the Historic England website. So the ability to check these things is now a lot easier than it has been in the past. But similarly, I do think there ought to be a greater onus on whether it's an auction house or a gallery as part of their due diligence to check these things, because they are the experts in researching the provenance and history of these objects. And therefore, checking whether something is listed should be able to come up easily and quickly in the early stages of the process of putting something for sale, rather than it appearing at the later stages post-sale. Similarly, if it is listed, it can then possibly trigger the need for an export license, which then of course can then prevent it from leaving the country. While it may no longer be in its original position, but hopefully again it sort of still protects it as a heritage aspect. So there are a couple of mechanisms that can hopefully prevent things in coming into the art market and not being available any further.
Yes, I think it sort of kicks in a couple of elements. Certainly the major auction houses, and it also was the case here, have been aware of these issues. So usually they manage to get spotted before something's put on sale rather than coming up afterwards. And as Rebecca, as you say, the information that's available online is now more thorough and easier to search. It is something that does impact on exports, and the Arts Council England, who deal with export licensing, I know have raised the question with clients as to whether or not a particular item was lawfully removed from a listed building, or, for example, where it was treasure. So the point does get picked up by the export licensing authorities. And if something has been unlawfully removed from a listed building, was a listed building itself unlawfully removed, then listed building control will still apply to it. Case of Leominster, where a barn had been demolished, dismantled with a view to then shipping over to America and reassembling. The court said, well, the listed whilst its unassembled pieces were still part of the listed building in that sense. But also, those items would be tainted cultural objects, subject to the Dealing in Cultural Objects Offences Act. And it then becomes an offence to dishonestly deal with them, which would include import or export, or for that matter, any sort of disposal or sale. So it's important for the art market that these issues are spotted ideally much sooner rather than later in that. I think what it does do is give far greater certainty all round as to what the legal tests are which are applicable. And it seems to me they had been a little bit unclear as to whether on the building side, whether you look at Skerritts or you look at the property law tests, and that's certainly been resolved.
I see there are a number of questions being asked, Richard. I just wondered if we address those. One that stands out is a an understandable practical question, which is what do I advise clients if they want to move something that is listed, but they think clearly isn't a building? I think the short answer to that is there is an informal process whereby you can ask Historic England to consider delisting the building. I believe there is at least one case of that process being used in circumstances where what was being alleged was that it wasn't a building. In fact, I think you personally dealt with that. Is that right?
Yes, I one statue where which was a loan item which had been listed, and then the conclusion was reached that it wasn't actually a building, so it was rather quietly delisted. I think it's since been donated, and likely that it will, given it's now definitely permanently in place, it likely that it would get relisted.
Again, I think it would be useful if Historic England were to make clearer its position on that. Is it going to consider delisting requests where the substance of the case is it actually isn't a building?
I think it's important. There seem to be potentially sort of two situations. One is you have something which might be curtilage listed or might be listed by reason of being fixed. So you don't have to alter the list description. We're debating whether or not the extended definition covers it. Mm. And my experience is usually what the owner would do is, having taken advice, then seek to obtain the agreement of the local authority, and particularly if it's a very sensitive building, Historic England, that the items aren't subject to the listed building list, in which case you can then dispose of them on that mechanism, and if need be, put a listed building consent application and appeal it as a way of resolving that issue. If items are specifically listed, then it seems to me the obvious mechanism is with Historic England, and Secretariat has a discretion to consider a request for delisting. A point that's picked up by one of the other questions is that there is the process of owner consultation, which is informal and doesn't always happen, and the opportunity to review. Now, in terms of the Dill case, we discussed that quite extensively in the court, and the informal opportunity wasn't seen as being a substitute for the right to challenge on appeal. It seems to me in many ways that actually fits in. The appeal mechanisms are amongst the formal mechanisms for doing it, but usually what you want to do is to try and resolve the issues with the local authority if it's extended listing, or it's Historic England if you want to change the list, to do that. And looking at,
there's another question about the means by which something can be delisted. I mean, seems to me they're limited in number. If at the point where the item becomes listed, obviously that decision is susceptible to judicial review. So that's one mechanism. There's the Historic England delisting mechanism, which we've just discussed. Or now, following Dill, there is the not to be recommended, just to remove it and then claim it wasn't a building when you get to a list of building appeal. I don't think anybody would recommend that. But it is, that is a means of challenging it, as you mentioned, applying for list of building consent to remove it.
Yeah. Okay. Let's just pick up some of the other questions we've had in terms of challenging the listing. Is a means of doing that other than applying for it to be delisted? I think the other means would be by a list of building consent application and appealing that. Now, that point is left actually slightly open by the Supreme Court, because Lord Conworth took the view that the enforcement notice appeal could deal with all the issues which could have arisen on the list of building consent appeal. Therefore, he didn't need to resolve whether or not whether it was a building could arise on the list of building consent appeal. I think that's right, but I think that sort of follows the line he was going down to think it would. And in terms of the extended definition, there's the High Court case of Chambers and Guildford Borough Council, where somebody had the pleasure or otherwise of having an old Second World War pillbox, so defensive structure, a few metres away from their listed farmhouse. And the court took the view that that was an appropriate issue for the inspector to decide whether or not that was an ancillary structure to the farmhouse, and so was caught by the extended definition. So to pursue the appeal process. And that also enables, it gives you two options, because you can argue that it's not subject to the listing or it's not a building, but also at the same time seek consent to remove it. And really we're arguing that case in respect of some 18th century chandelier in a chapel, where we, on this building consent appeal, argued first of all it wasn't actually part of the building. We lost that point, but then succeeded in getting listed building consent for its removal, largely on the basis that the rather Baroque design it had got, even been chapel for 2.5 centuries, didn't actually fit in with the Palladian style of the chapel. So it was better to replace it with something antique but less expensive in doing so. So you can go through those processes. And there's a point to have in mind on Dill, which is really in the High Court judgment, which is that one of the other reasons of the inspector for throwing out the list of building consent appeal was that he said that an application to remove the listed building was not valid, where it didn't say where the building was going to. And it was conceded that by secretaries in the High Court that the inspector was wrong as a matter of law of that. Perfectly lawful application, say we want to remove this part of the building or remove the building, which doesn't say where it's going to go to. The court, though, did take the view in the Dill case that even if the inspector hadn't made that error, he'd have still refused consent on his view of the merits. But that's a useful aspect when it does come to making consent applications to remove works of art and the like. We just look through all the other questions. Question: had the statute treated buildings as a legal fiction in this case, would the case have reached the Supreme Court? I think there's a question of what the regime is about, and so structures and erections is quite deliberately quite wide, but then becomes vague and really needs to be qualified as to what it's dealing with. And I think the problem probably was at the start, it simply wasn't really being thought about when it was originally listed, I suspect, in doing so. Fair point to make about so it makes about local authority, conservation officer resources. And I think what that does point to is that where these issues arise, it's very much in the interest of the owners to bottom out the issues, get appropriate advice, and then put an informed position in front of the authority for it to take a view, and also for Historic England, particularly on the Grade 1 and Grade 2 star listed buildings, to be looking at those issues. And I know quite often Historic England have been involved with local authorities at looking at these sort of artwork related topics and helping out to reach a conclusion on that. Okay, we'll try and pick up as many questions as we can in the next sort of few minutes. One question about objects and purpose for installation of work of art seems to be critical. How the panel determine whether a sculpture was an ornament in the host grounds or work of art, ornament to the host grounds or work of art in its own right. Rebecca, you have any thoughts about how you'd apply either the Skerritt's approach or the property approach in a case?
Sorry, there's a problem with the sound there. I think it's a question of applying looking at the structure itself and the surrounding features of it, and seeing what may be present, and how it, the size of it, and how it's, you know, the permanence of it. I think it will, each individual case will have to be analysed case by case, which might be a long process, but I think it will provide greater clarity in the long run.
Yeah, I agree. I think it is kind of, I think if you're looking at skerrits, you are looking at permanence. That does bring in the question, well, why it's there. And the approach to the property test, you're looking at, is this work of art there as a means of enjoying the work of art, or is it there as part of the design of the garden if it's outside, or as part of the design of the room in the house? And so as part, it's to my mind, part it's a matter of history. It's going to the art historians and seeing what's happened to the items and whether they've moved around the gardens. And to some extent, it can be a matter of impression. And as one case, I was being asked to advise whether in a variety of paintings in a variety of rooms in a house were fixed, and so were part of the building, and so subject listed building control. And something you can say is, but it still enjoy the paintings. But did go into one of the rooms, which was a library, where somebody redesigned the library, had identified a variety really of his heroes, and had paintings of them put up all the way around, so you could sit in the middle of the library and be surrounded by his heroes. And I just walked into there and thought, this is a complete room, and the paintings are part of the room. And in that case, it seemed to be they were part of the building.
Exactly. I mean, yeah. As you point out, I think it's going to be so individual to each situation, which has generally been the case so far, which is probably what makes it more complicated. But you know, with larger gardens, a lot of the time they have been designed, and it is understandable that they will change. But as long as there is we can see a sort of detailed thought process and pattern to those changes, then it will help identify which features are inherent to the garden itself, and the same for items within houses, within buildings as well. You know, it is part of that whole process. And I think the two tests, you know, whether we're looking at the extended definition or the building itself definition, it should provide a great more clarity.
Yeah. Okay, just pick up a few of questions. One is how this would affect fixed machinery inside an industrial unit. I mean, there is an exemption from the definition of a building for plant or machinery within a building, and that's a bit like sort of the ability of tenants to remove their fixtures. So you have a question whether or not the machinery fell within that exception, I think, on that. But Nigel, can I sort of throw this one your direction, whether there's an enabling development argument if one applied to delist an item so that it could be sold to raise funds for refurbishment?
I'm not sure that's an enabling development argument, because if it would be delisted on the basis that it should never have been listed in the first place because it wasn't a building. So the owner ought to be free to sell it regardless of whether it then funds other development. And I can see the argument if you were allowed, if the item were to remain listed. You know, this is assuming it's listed in its own right. If the item were to remain listed, and the local authority might grant listed building consent for its removal in circumstances where it might not otherwise do so, on the basis that the proceeds would then be used to refurbish the rest of the building. I don't see the argument on delisting, because it should never have been listed in the first place, and the owner ought to be free to sell it regardless.
We just sort of Question about if you want to move listed garden structures in the same grounds on another site, should you look to delist or apply for listed building consent? I think it seems to me it probably comes down to the first question: is are they buildings for listed purposes specifically listed, or are they caught by the extended definition as curtilage structures? And if the answer is they're not buildings but they're listed, then I think obviously you'd look to delist. If they're caught by the extended definition, sorry, not caught by the extended definition, then you can just move them. But if need be, get agreement on that, and if they are, you conclude they are listed, then seek listed building consent, which might include saying that they're not of special interest.
On that point, it's worth noting that in the past, when something has been moved from one room to another, I can't remember the name of the case, but it concerned a relief sculpture by an artist, Dill, in a hotel in Devon, I believe. It was commissioned to be in the main hall of that building. It had been moved previously, sometime during the war, to avoid destruction, but it was then moved back and then moved into a boardroom. They were made to move it back into the hall because listed building consent hadn't been sought. So it is sometimes tricky. So it is always worth consulting with the local planning authority and Historic England on whether or not, even if it is caught within the curtilage, that it needs, even if it's just moving, even if it'll be the same building or garden, it is worth checking, because sometimes it doesn't always, the council won't agree.
Okay, I'll just pick up perhaps the final two questions. Question as to whether or not there's any equivalent of a heritage impact assessment having been carried out in the Dill case. Well, we think there was some assessment by or on behalf of English Heritage when the building was originally listed, but unfortunately one of the complications of Dill was that the original listing documentation has not been found, even though I've done cases and seen cases where quite old listing documentation has been found, but it wasn't found in this case. So we don't know what the assessment was. And since then, there's not really been a detailed assessment on the merits, although some of the merits will come into the later grounds of appeals on the issues which arose. But ultimately, the case sort of proceeds in through the courts on the is it a building point. And then perhaps the final question to pick up as to how perhaps I suppose these smaller heritage assets can be protected if not through the listing process. I mean, has a problem cropped up here that wasn't anticipated, or has the court sort of struck the balance in terms of what the legislative regimes are trying to achieve? Any sort of final thoughts on those?
I suppose any smaller items, we know with paintings that they can be designated as national treasure, which then prevents them from leaving the country without an export license if a national buyer can't be found. While it doesn't mean that it can stop them from moving location, at least it can prevent them from leaving British ground. However, whether or not that's enough of a protection is dependent on whether or not, as in the case with listed buildings, we need to take into account the setting of these items. So it's not a complete protection, but I think it helps to strike a balance between the different items.
Yeah, I see. It seems to me what the court is emphasising, what Lord Comfort was keen to emphasise, was that there is a distinction between listed building control, which is about buildings which have a significance because they're seen as buildings, and a large part because of the context they're in, and objects. And broadly speaking, legislation doesn't protect objects in the same way. It doesn't require objects to be kept in the same place. you may have a historic collection of books or a historic collection of stuffed animals or whatever it is. And the legislation does not require that collection to be kept together. May well be that through inheritance tax exemptions and so on, it's come to be the position that it does need to be kept together. But the legislation broadly doesn't require that to be kept. As Rebecca says, the protection which is provided is export licensing control if the items have been taken out of the country, application of the Waverley criteria in terms of their significance, and potentially a stop whilst a public institution, or potentially somebody else, has an opportunity to buy the item so it's retained in the country. But there isn't that connection in the legislation between objects and where they are. There's protection of buildings, and there's then the ability to move objects around, subject to the question of export control. Personally, that seems to me to be a sensible distinction, but I'm sure there are going to be a variety of views on that.
I just think it would be a system that sought to protect things that are clearly just objects would be unworkable.
Okay, and I think that takes us through the questions.
Sorry, there's one follow-up to the machinery point. I think the point about machinery is if it qualifies as either an object attached to the building or a curtilage object, so it satisfies the degree of annexation, purpose of annexation tests, then it is part of the list of building and accordingly will be protected. If it doesn't, then it isn't. I think is the short point there.
And also there's plant machinery exception in the definition of buildings, but we can come to that after for the questioner. Any sort of final thoughts on what we've been talking about? Okay, well, thank you everyone for watching, if indeed you still are. Very much enjoyed this. The recording will be up online on the 13 Essex Chambers website very shortly. So something to sort of torment the children with in due course. But thank you very much, and we'll see where all these issues go. Okay, goodbye.